Court will note the appearance of Ms. Huffman on behalf of the defendant. This matter is before the court on the defendant's motion to modify custody and parenting time. The plaintiff is present. I guess I'll ask Ms. Huffman. I note that the matter was before the CPS for an investigation. Is that been completed, or what's happening with regard to that?
So I would have to ask my client if it's still going on right now. The last I knew it was. I think the last time I talked to him, in fact, he had an appointment with the CPS worker like that day or the next day. So I would have to confer with him real quickly.
Okay,
if the court would like to, that's fine.
Well, hopefully you should have done that before the hearing, so we would know. Miss Copic, are you aware, is the CPS investigation still ongoing?
I have not been contacted by any CPS or cops.
Okay.
I'm not aware of any CPS case.
Okay. Well, at this point, again, that would be the basis. It appears that that's the basis for your motion for modification.
Well, if I could, Your Honor, I don't think that's the only reason. My client has been having week on, week off parenting time for 4 years. The order actually states that mom has sole legal, sole physical custody. So as soon as summer parenting time is over, it's been my client's been informed that parenting time is going back to the way it was. Weekends or however often mom wants it to be. That's proven by the fact that she just filed a motion just a couple of months ago that indicates that she wants it to go back to the way it was. Well, after 4 years, we already have an established custodial environment with both parties having week on, week off. We need an order stating what the parents have been doing for 4 years. It's imperative. Otherwise, this child is going to go back to a full-time custody with mom.
Okay. I'll ask Ms. Copic, is it accurate that he has had alternating weeks for 4 years?
Yes, but when I came into the courtroom last month to try and change it back, I had documents showing that he did not have reliable transportation to and back to his house to take her to school. So I was putting it to where she needed to have the reliable transportation to school. So I wanted it back to weekends, and then she would have transportation to the house. So
I will tell you, obviously, if he's had alternating weeks for 4 years, that's pretty substantial. I'll tell you, I'm not going to, again, decide an issue of custody based on whether somebody has appropriate transportation or not. That's a minimal issue compared to all of the other factors the court has to look at. So if that is your objection, I will let you know that it's not going to hold much water with the court in this particular matter.
She missed 15 days of school last year, and going back through the days, those were mostly on his days. And I actually have proof conversation with his girlfriend, Ashley Pond, stating that he did not leave the keys for the truck for her to take her or the gas money, and that he's done this to her multiple times to not be able to.
Well, that's something we'll have to address at an evidentiary hearing, but you did say mostly, so it means that not all of those days were attributable to him. So I guess it'll depend on how many were attributable, how many were not. But the court is going to have an evidentiary hearing in this particular matter because, again, based upon what the allegations are, again, it does appear that there is sufficient basis to meet the threshold of AVARCA for an evidentiary hearing. But I guess I'd say it's for the defendant, if there was an issue with transportation before that hearing, you need to get that taken care of. So that's a non-issue. But in any event, we'll have an evidentiary hearing. What we'll do is my office will contact Ms. Huffman, and we'll contact you as well, ma'am, and find a time when you're available. and we will get that hearing in as soon as we can. So anything else, Ms. Huffman?
Yes, could I do an order or something to make sure that they continue status quo week on, week on?
Ms. Copic, is there any problem with continuing the alternating weeks until we have our evidentiary hearing?
As long as she stays into the school district that she is in, I have no problem with that.
Well, I don't care if he stays in the school district as long as the child continues in the same school district. So if the
Okay.
That's
child
fine.
continues, he could transport the child, and if he's in a adjoining school district or another school district, he can still get the child to school, and that's his obligation. I will tell you, sir, if in fact there are continued issues with getting the child to school, as she states from last year, that is a factor that the court will consider as to whether the court should consider the alternating weeks. But at this point, Ms. Huffman, you can do an order which would state that the parties would continue the alternating week parenting time, and that the child would be transported and go to school. And then we will have a hearing at the time that everyone is available.
Okay.
Sir, can I add that Mackenzie is also in a cheerleading with school because she wanted to and then interact with other children. So on his weeks, is he made to take her to and from cheerleading?
I will do all of those things.
That's an activity that the child has, so he should be responsible for doing that. And if he doesn't, again, it's something we can take into consideration when we are determining whether we would change custody to that alternating week on a permanent basis. So that will be the order of the court. Ms. Huffman, you can submit under 7-day notice of entry, and then we will be in touch with you and get a date when everyone is available.
Thank you. Sounds
Okay.
good. Thanks.
Thank
Bye.
you. Have a good day.